Ladies and gentlemen, it's my great pleasure to welcome you to the ESMT Open Lecture today with Aryeh Neier. The lecture titled Surveillance, Secrecy and Disclosure, the Case of Edward Snowden, an event that we organized jointly with the American Academy in Berlin and the School of Public Policy at Central European University. For those of you who have been to ESMT Open Lectures before, the next couple of sentences might be superfluous. For those who haven't, let me just give a brief introduction. The ESMT Open Lecture series focuses on questions of current intellectual concern related not only to the economy, but also to business, politics, society. It takes a rather broad look at aspects of current concern. And I think I can say without any hesitation that the topic we see today is one of current, very important concern. This is always meant as an interactive forum in which we invite the speaker to first provide her or his views, then to be followed by questions and answers. So this means we actively encourage you to also ask the questions you have in mind. The Open Lecture certainly, as at a business school, also has business implications, but many of these open lectures that we've seen actually have stimulated debates on a much broader level. Topics such as inequality, ethics, in particular when it comes also to executive pays, and debates on why nations fail. So a fairly broad set of topics. And in particular, thus, we are very delighted to have an open lecture today on such an important topic that is so much of concern these days. In particular, we are delighted to hear on this very important topic from such a highly respected authority on human rights, who actually brings this topic, will illustrate this topic in a very vivid and in a very sophisticated way. I will not spend much time on introducing our distinguished speaker today, but rather leave this to Gary Smith, the Executive Director of the American Academy in Berlin. I'd like to say, and I say this with a lot of pleasure, that many of these open lectures, many of the joint activities have been jointly undertaken with the American Academy. We're very proud, very delighted about this very fruitful, this very engaging cooperation ESMT and the American Academy have. And I'd also like to say I'm very thankful and very delighted to include the School of Public Policy at Central European University here as well. And we look also very much forward to continuing furthering our exchange here. Finally, I'd like to thank, as our continuing supporter on the media side, der Tagesspiegel, again, a cooperation that has lasted for a long period of time. With this, and without any further ado, let me then hand over to Gary Smith to really introduce the topic, the speaker of today. From my side, a warm welcome, and I wish us a very engaging and stimulating debate. Thank you.
Thank you, Jörg. Yes, I think you could say that surveillance and secrecy are topics with business implications, and others as well. Now, I want to welcome you on behalf of the American Academy to this collaboration with the ESMT, which has a good history, and I hope that it will be continued long into the future. This is really an initiative, though, of the new School of Public Policy at the Central European University, which was launched only in September of 2011, where Aryeh Neier is teaching at present. And I want to welcome its founding dean, Wolfgang Reinecke, who is a familiar face in Berlin as a co-founder of the GPPI, and who's also a non-resident fellow at Brookings. Thank you very much, and I hope this is the beginning of a long-standing relationship as well. I want to thank the Daimler Fund for their support of our Foreign Policy Forum, and Sylke Tempel, the editor-in-chief of the Internationale Politik, who will be moderating today's discussion. I also want to welcome our trustee, John Kornblum, former U.S. ambassador in Germany, and my colleague, I don't see her, Susan Nyman, who actually hosted you 10 years ago at an important conference on terrorism, international law, and the bounds of democracy. So themes that that the Einstein Forum has pursued, and the Academy as well. I'm very grateful, though, we're all very grateful, all of us here and those who will meet with you tomorrow and during the day, that you've made this trip from Budapest to Berlin. I only met you a few years ago, but it was at a very meaningful occasion because it was the inauguration of an award named in memory of our founder, Richard C. Holbrooke, the Richard C. Holbrooke Award for Social Justice at the anniversary dinner of the Blue Card Foundation, itself a remarkable story. And of course, anyone who knows Holbrooke knows that human rights, refugees, citizenship, these have all been topics that he cared very deeply about. They've been the topics of recurring study, debate, of fellows projects or visitors at the Academy. And how could it be otherwise? This is who he was. And so it's wonderful to have you return to a Holbrookian institution. As his widow, Kati Martin, said then, Aryeh and Richard were cut from the same cloth, children of German Jewish refugees, first generation in Aryeh's case, second in Richard's. They shared a visceral distaste for bigotry and an insatiable appetite for combating it. I added insatiable because it's true. Aryeh, like Richard, is fearless about speaking out to the powerful and uses his pen as forcefully as Richard did. And his contributions have been legendary. Aryeh Neier joined the staff of the American, and this is just an excerpt from his life, but he joined the staff of the American Civil Liberties Union in 1963 and soon became its youngest executive director. Ever since, he's been at the forefront, both in the United States and internationally, of efforts to fight for civil liberties, human rights, and social justice. And in my opinion, his achievements as an institution builder are also unmatched. He co-founded the Helsinki Watch in 1978, which then, of course, evolved 10 years later into Human Rights Watch, probably the most effective and visible international human rights organization at present. And then, after serving as its executive director for 12 years, he became the founding president of the Open Society Foundation. Somehow he found time in between to teach for 12 years at NYU Law School, as well as Georgetown University's Law School, Sciences Po in Paris, and of course the CEU in Budapest, as well as other places, as well as to write, I think, 11 books. 7. Maybe 11 were contracted, or anyway. And I recommend a number of them, but certainly his autobiography, which is important both in its, of course, it's not just a record of achievements, it's a self-reflective, self-critical record of how one could have done things differently, taking liberties for decades in the struggle for rights in 1995, and more recently, his history of the international human rights movement. Aryeh Neier has been said to be methodical, relentless, and of course he's been very successful. He hasn't shied from public debate and has recently been, of course, very visible, very articulate on the subject of the consequences of the case of Edward Snowden. It's not a new theme for him by any means. In 1975, he published a book entitled Dossier, The Secret Files They Keep on You, but clearly looking at privacy as a human rights issue has been a lifelong preoccupation of Aryeh Neier. So we're very grateful that he's come to Berlin to speak to us today on surveillance, secrecy, and disclosure of the case of Edward Snowden. And please join me in welcoming an extraordinary individual who's dedicated his life to advancing human rights around the world. Thank you.
Thank you very much. I'm very glad to be here today. I'm particularly glad to be here because this is the city of my birth. I was 2 years old when I left, so I actually have no recollection of Berlin from that period. But I'm glad to be back in the city today talking on this subject. I'm also glad to be here because I think the disclosures by Edward Snowden have had a particular impact here in Germany, and it's important to discuss these issues here. When I teach a course on human rights, as I am doing right now at the School for Public Policy of the Central European University, one of the things I tell my students is that the conception of rights in the United States and the conception of rights in Germany have a great deal in common, but they also have differences. The fundamental value that Americans see in the idea of rights is that rights protect liberty, and that is an outgrowth of the struggles for religious liberty in 17th century England and the struggles of the American colonists for liberty vis-a-vis the government of Britain. On the other hand, I suggest that the central value in the German concept of rights is the idea of dignity. And the dignity as a concept has different roots, but among them are its roots in Kantian philosophy. But the importance that dignity has in the Grundgesetz, which starts with the statement that human dignity is inviolable, grows out of the experience of Germany under the Nazis and during World War II, and reflects a reaching back to the idea of dignity that is embodied in Kantian philosophy. And dignity and liberty are not contradictory. I think they are complementary values. But the one looms largest in the United States, and the other, it seems to me, looms largest in Germany and perhaps to a lesser extent in other countries of continental Europe. I think the liberty ideal, it tends to be more characteristic of the Anglo-Saxon countries, where there is that collective memory of the struggles for liberty in England. The concept of dignity, it seems to me, embraces the idea of privacy. And there are a number of references to privacy in the Grundgesetz. There are no references to privacy in the American Constitution or the American Bill of Rights. We do have in the Fourth Amendment to our Constitution a prohibition on unreasonable searches and seizures. But that meant to the people who were the framers of the American Constitution essentially the idea that an Englishman's home was his castle, and the state could not enter the home of even the humblest person unless the state obtained a warrant from a court. But when American courts have tried to deal with the idea of privacy, they have had to reach very far to protect privacy. So we have a famous Supreme Court decision of the United States in which one of our Supreme Court justices talked about the penumbras emanating from other parts of our Bill of Rights, which he argued created a right to privacy. But privacy is not a well-established constitutional right in the United States. I think most of my fellow Americans don't really have a grasp of the difference in philosophy that tends to inspire people in continental Europe generally, and in Germany in particular, when it comes to rights. In trying to discuss the issue of the case of Edward Snowden, I thought I would pose a series of questions and then attempt to answer my own questions. But before I do that, I want to talk very briefly about two other things. The first is I want to use a few examples of the importance of whistleblowing, that is, of individuals who discover wrongdoing and then take certain risks and often pay significant penalties in order to disclose the wrongdoing that they discover. And I thought I would select four examples, one from here in Germany, one from the Soviet Union, one from the United States, and one from China. The four that I've chosen, I'll start with the German case, and I apologize in advance because I'm sure that a great many people here know the details much better than I do, and I hope I don't get anything wrong. But the case I have in mind is Karl von Ossietzky. Karl von Ossietzky was an anti-war activist and an early human rights campaigner in Germany in the 1930s. And Mr. von Ossietzky published information about Germany's rearmament in violation of the Versailles Agreement. He was both honored for this and he was punished for this. He was honored for this because he received the 1935 Nobel Peace Prize, but he was forbidden to attend the ceremony at which the prize was awarded. Hitler had him imprisoned, and he contracted tuberculosis in prison and died as a result. Many years later, members of his family went back to court here in Germany in order to clear his name. But in 1992, the Federal Court of Justice affirmed Mr. von Ossietzky's conviction, saying that he owed a duty of secrecy to his country and was not privileged to violate that duty of secrecy. They didn't condone Hitler's treatment of him, but they did affirm his criminal conviction for disclosing that information. The example from the Soviet Union that I want to cite is of the great physicist and great defender of human rights, Aryeh Sakharov. Aryeh Sakharov, as a nuclear scientist, in 1968 became persuaded that the competition between the United States and the Soviet Union with respect to an anti-ballistic missile system would lead in the direction of nuclear war. And so Sakharov published in samizdat, that is, unofficial publications not authorized by the state, information about what he thought would be an impending nuclear disaster. His writings in samizdat were then published in a Dutch newspaper and then published in the United States and came to world attention. He was removed from any role in scientific work on behalf of the Soviet military, and that is where Andrei Sakharov's career as a dissenter and as a defender of human rights started. The American example is of a man named Daniel Ellsberg, who was a staff member for the Defense Department in the United States, who became aware of a study that was done in the Department of Defense about the origins and the escalation of the Vietnam War at a moment when that was by far the most controversial issue in the United States. And Mr. Ellsberg gave what were called the Pentagon Papers to the New York Times and then to the Washington Post, which published them. He was prosecuted for this disclosure. He was prosecuted under the Espionage Act, a law adopted in 1917 when the United States entered World War I, and was threatened with a very, very long prison sentence. Incidentally, that's the same law under which Edward Snowden would be prosecuted if he comes into the custody of the United States. Mr. Ellsberg didn't get convicted because during the trial, the judge learned of misconduct by the government in the prosecution, including wiretapping of Ellsberg on an unauthorized basis, and also the government had initially lied to the court about whether the wiretapping had taken place. And so the charges were dismissed, and he got off because of the misconduct of the government. And then the Chinese case I have in mind involves a man named Bao Tong, who is today 82 years old. Bao Tong was an aide to the Communist Party secretary, Zhao Ziyang, and both he and Zhao Ziyang were reformers. Bao Tong was the leader of the reform group within the Communist Party in China. And when students occupied Tiananmen Square in 1989, Bao Tong went to the square and warned the students that if they didn't discontinue their protest, the government would invoke martial law. In the process, he probably prevented or helped to prevent the massacre of a much greater number of people than the number that actually died at the time of Tiananmen Square. But after Tiananmen Square, he was prosecuted for disclosing state secrets. He spent 7 years in prison, and since he got out of prison, he has been under 24-hour surveillance in Beijing. The police monitor every movement to and from his apartment in Beijing, and he is not allowed to to travel any place, and he continues under these circumstances today. The other area that I want to talk about before getting to the questions is the history of surveillance in the United States. It has a very long history. At a federal government level, it probably begins in 1908. We had an Attorney General of the United States named Bonaparte. He was actually a collateral descendant of Napoleon Bonaparte. And Mr. Bonaparte, on his own, created a Bureau of Investigation in the Department of Justice, which engaged in political surveillance. And it was particularly active during World War I. There were many people in the United States who opposed American entry into the war. There were people who opposed the draft. Many hundreds of them were prosecuted and went to prison during World War I, and that was based on the surveillance activities of the Bureau of Investigation. And after the war, there was a Red Scare in the United States. The Bolshevik Revolution had triumphed in Russia. It was a period of many labor strikes. It was a period of significant anarchist activity in the United States, and many thousands of people were rounded up by the Bureau of Investigation without legal process, and many hundreds of them were deported from the United States without legal process. A few hundred were put on a ship that took them to Russia, and then they were dumped in Russia. And that was based on the surveillance activities of the Bureau of Investigation. And it was then renamed the Federal Bureau of Investigation, the FBI. We had an Attorney General of the United States in 1924 named Harlan Fiske Stone, and he put restraints on the FBI. And the restraints lasted for about 15 years until World War II broke out in Europe. And then Franklin Roosevelt authorized the FBI to resume its political surveillance activities. And about from 1939 until 1972, most of the work of the FBI was political surveillance. That is, it targeted dissenters, it targeted leftists, it targeted anti-war activists, it targeted civil rights activists. For example, every black student organization at every college in the United States was a target. It targeted the emerging women's rights movement, the American Indian movement. And it did more than target them. It had a program that was called COINTELPRO. And this was a program to disrupt the activities of the organizations and to disrupt the personal lives of the people who were the dissenters, to circulate information, for example, that they were engaged in fraud or taking money from the organizations with which they were affiliated, or circulating information designed to break up marriages. In the case of Martin Luther King Jr., they tried to persuade him to commit suicide. There was a long campaign along those lines. That came to an end in the United States in the early 1970s. Several things coincided to bring it to an end as far as the FBI was concerned. But it's important to know in terms of the United States that it was not only the FBI that was doing it. Many of our federal government agencies the Internal Revenue Service, the Passport Office of the State Department, and even the United States Army were engaged in political surveillance. A whistleblower of that period in 1970, an Army captain named Christopher Pyle, disclosed that the United States Army had more than 1,000 personnel assigned full-time to engage in surveillance activities, mainly targeting anti-war activists of that period. The revelations about the Army political surveillance were one of the things that helped to discredit political surveillance in the United States. Americans didn't think it was a good idea for the Army to be engaged in activities of that sort. Another major development, of course, during that period was the Watergate scandal, and the Watergate scandal epitomized the Nixon administration's particular engagement in political surveillance. Political surveillance reached its high point in the United States under Richard Nixon. And when Nixon was discredited and forced to resign, and the disclosures about the Army surveillance took place, and the longtime director of the FBI, J. Edgar Hoover, died, all those coming at about the same moment, it triggered a series of congressional investigations, court cases, administrative reforms, and a large part of the political surveillance activity at the federal government level ended in the 1970s in the United States. In addition to the federal government surveillance, we had very extensive political surveillance by urban police departments. They all had their own red squads. And in New York, the red squad is called the Bureau of Special Services, or BOSS. And BOSS had files on more than 1 million persons in New York City. The Chicago equivalent had files on more than 400,000 persons. And you could go around the country, and every urban police department had some counterpart. And it was more than just collecting files. The files were used particularly to deny jobs to people seeking either government employment or employment with many private businesses that had access to the files. So typically what would happen is private businesses would hire retired police officers as their company security people. And those company security people would talk to their old colleagues in the police department. And when they had a job application, they would say to their colleague, "Do you have anything on so-and-so?" And if they had something on so-and-so, that person would be denied a job. And there were also lawsuits against the urban police departments in the 1970s. And up till today, many of the urban police departments operate under court orders in which their surveillance activities are restricted. Many of those same police departments went back to court after 9/11 to ask for modifications in those court orders, and they often got modifications in those court orders to allow them to once again increase their surveillance activities. So that's a brief overview of the history of surveillance in the United States. Now, let me tell you the questions that I want to try to answer today. The first question is, do we need the political surveillance activities of the National Security Agency in order to mitigate or reduce the threat of terrorism. And a second question, which I think is closely related to the first, do these surveillance activities excessively intrude on individual privacy? And the third question is, if we need these surveillance activities and the intrusion on privacy is not too great, is it appropriate to keep these surveillance activities secret? And the fourth question, again related to the previous question, is the effectiveness of these surveillance practices significantly reduced by their public disclosure? My fifth question is, could the surveillance activities of the National Security Agency have been disclosed in some other way? And the final question is, if they could not have been disclosed in some other way, was Edward Snowden justified in unilateral disclosure? I want to say also that as we go along, one needs to differentiate a little bit between the surveillance activities that have been conducted in the United States and the surveillance activities that have been conducted internationally. In one respect, I think it's less bad in the United States. In another respect, I think it's worse in the United States. I think it's less bad in the United States because the National Security Agency and the government recognizes that there are certain constitutional and legal limits on its surveillance in the United States. And so the main form of surveillance we know about so far through Snowden's disclosures in the United States involves the collection of what is called metadata. And metadata means that we know from what number calls have been made to what other number. We know the date and time and duration of those calls, but we don't know the content of those calls. In order to get the content of the calls, the National Security Agency would have to go a step further and get a court order allowing it to listen in on the actual content of the calls. So in the United States, it is metadata that is principally collected. The National Security Agency and the government of the United States don't recognize that there are any legal limits on its ability to collect information outside the United States. And so outside the United States, they actually listen in to calls. And it's clearly worse to have them actually listening to the content of the calls than only to collect the metadata. Moreover, from Snowden's disclosures, we know that some of the information that has been collected has nothing to do with the threat of terrorism. They weren't listening to Chancellor Merkel's calls because of a concern about terrorism. They weren't listening to the calls of President Dilma Rousseff of Brazil in order to deal with terrorism. Apparently, they weren't interested in terrorism in the monitoring that was done of Indonesian calls related to trade relations and the monitoring of an American law firm that represented the Indonesians in the trade negotiations. So the National Security Agency sees some limits on what it can do within the United States. It doesn't see limits on what it can do elsewhere. On the other hand, the argument that it could be worse in the United States is that the National Security Agency or the government is clearly in a position to take action against Americans that it would not be able to take against people in other parts of the world. So potentially, the information that is available on American calls can be used in a more significant way than the information that is available on calls outside the United States. And although we don't know that the information is now being used for personal harassment as the information was used during the high point of political surveillance in the United States, there's no one who can guarantee that we won't again have officials like a J. Edgar Hoover of the FBI or a President Richard Nixon who were willing to use information that was collected for one purpose for their own political purposes. So the existence of the information is potentially a significant threat to Americans. Also, when I describe metadata, it isn't so minor a matter as it might seem. It actually does furnish a lot of information. We had a case that didn't involve the National Security Agency in the United States Supreme Court in 2012 that also involved the collection of metadata. And one of our Supreme Court justices, Justice Sonia Sotomayor, said that this metadata can reveal calls to the psychiatrist, the plastic surgeon, the abortion clinic, the AIDS treatment center, the strip club, the criminal defense attorney, the by-the-hour motel, the union meeting, the mosque, synagogue, or church, the gay bar, and so on. If you know all the calls that a person has made, you actually know quite a lot about that person. And so I think there is a significant potential threat to Americans. Now, dealing with that first question, the question of do we need the surveillance to mitigate the threat of terrorism. We have had recently two public bodies that have reviewed the information that is available and have had access to all the information. President Obama appointed a review group to look at this, and Americans particularly know the name of one of the members of the review group. He's a man named Richard Clarke, who was the top counterterrorism official in the State Department, and he was the official in the White House who tried to warn President George W. Bush and Secretary of State Condoleezza Rice that Osama bin Laden intended to attack the United States and that they should take that threat very, very seriously. And he's widely recognized in the United States as a leading expert, if not the leading expert, on counterterrorism. And that review group, which issued a book-length report in December, said that the activities that had been revealed of the National Security Agency are, quote, not essential in preventing attacks. And then we had another body called the Privacy and Civil Liberties Oversight Board, which issued another book-length report in January. This is a bipartisan body and it also had distinguished membership. And it was more detailed. What it said is, we have not identified a single instance involving a threat to the United States in which the program made a concrete difference in the outcome of a counterterrorism investigation. Moreover, we are aware of no instance in which the program directly contributed to the discovery of a previously unknown terrorist plot or the disruption of a terrorist attack. Now, that seems to me quite significant. I don't think it's the end of the story. I think that the administration or the National Security Agency continues to claim that its activities have disrupted terrorist plots or terrorist attacks, but they ought to come forward with detailed information on the attacks that they have disrupted, because it's difficult to take their word for it when these bodies that have looked at this question carefully come to an opposite conclusion. I think we may need more evidence, but so far it seems to me the case has not been established that this information is crucial. And that seems to me to relate directly to my second question as to whether these activities intrude excessively on privacy. I don't think of privacy as an absolute right. I do think of certain other things as absolute rights. I think of the prohibition of torture or the prohibition of slavery as absolute rights. Personally, I'm an absolutist so far as the content of speech is concerned. I believe speech should only be regulated in terms of time, place, and manner of speech, but not in terms of the content of speech. But privacy is something that we give up in small doses every day. We carry identification. We're aware that the police are on the street and they're engaged in surveillance activities, and in some places we feel safer because we see police on the street engaged in surveillance activities. If we want to board a plane, we give up a certain amount of privacy. I don't know the practice here, but in the United States, if a police officer stops me and says, you've been driving in an erratic manner, and I want to test you for drunkenness, I can either take that test, allow him to test my breath with some device that he has, or I will be arrested. And you give up privacy in small doses all of the time. But you give it up when you see something substantial in return. And the more substantial the return is, I think people would give up a little bit more of their privacy. They won't give up the most intimate details of their life, except in circumstances, let's say, when they have to deal with a physician about some significant ailment, but they will give up small amounts of their privacy. So it's a balancing act, and you have to be able to show that these activities have a significant role in preventing terrorism if you're going to be asked to give up any significant amount of one's privacy. Then the question is, if we need these programs for our safety and the privacy intrusion is not too great, was it appropriate to keep them secret? I think it was not appropriate to keep them secret. How can we know whether we should give up any of our privacy if we don't know what is being done. We don't know what's being done. We don't know whether it actually promotes our safety. Our only basis for giving up any privacy is our knowledge of what is taking place and our willingness to sacrifice some degree of privacy in order to get some degree of security. But if it's all kept secret, how can we possibly know? Should we simply put our trust in the National Security Agency to violate our privacy without even telling us what they're doing or whether it has any beneficial purpose? Of course, the argument against disclosing the programs is that this will compromise their effectiveness, that somehow the terrorists will be able to design their own activities so that they will evade the surveillance. I actually don't think it works that way. I think it's ordinarily the case that when we know about surveillance, it in fact enhances its effectiveness rather than diminishes its effectiveness. If you return to the question of the screening to get aboard an airplane, we know that screening is taking place. Suppose we did not know that it was going on. It was all done secretly. We were being electronically monitored without our knowing it. I think the chances are some more people would take objects onto the plane which would create difficulty. And some of them would be caught. But some of them might not be caught. Some of them might get away with it. And so we might end up actually diminishing our safety. But because we know the screening is taking place, we actually avoid carrying objects onto a plane, which we think will create difficulties. And I think it's the same here, that if you know that your communications are going to be monitored, I think you have to avoid engaging in certain kinds of communications. If you know about it, if you don't know about it, and they're just monitoring your calls, maybe they'll catch you, and maybe they won't. We don't know. They're not going to be 100% efficient in catching the people who might be concocting a terrorist plot. So I don't think there is an increase in effectiveness because the program is kept secret. I think it may work the other way around, but at least the case has not been made so far that these programs are more effective because they are kept secret. Then my fifth question is, could the surveillance have been disclosed in some other way? And my view is I wish the surveillance had been disclosed in some other way. I wish it had not been Edward Snowden who disclosed the surveillance. But our Director of National Intelligence, General James Clapper, appeared before a United States Senate committee in March 2013, and he was asked directly whether the National Security Agency collects information on the telephone calls of Americans. And he said, not intentionally. Even though he knew that the government for at least the last 7 or 8 years had collected information on virtually every phone call that was made in the United States. And most of the members of the Senate Intelligence Committee, in front of which he testified, maybe all of them, but most of them certainly knew that he was lying. And none of them said that he was lying. And so if the principal executive officer of the United States, who is responsible for this activity, is able to lie to the Congress of the United States about it. And the Congress is willing to accept the lie. And the president is not willing to take any disciplinary action against that official. If you've seen the pictures of the meetings at the White House over the Ukraine crisis, you've seen pictures of General Clapper going in and out of the White House in the last few days. He has in no way suffered any diminution of stature as a result of lying to Congress about this. So it doesn't seem as though there could have been a more orderly method of disclosing the information. Finally, is Edward Snowden justified in disclosing this information unilaterally? I started out unenthusiastic about Mr. Snowden. I didn't like the fact that he sought the assistance of China and then Russia in disclosing this information. Those seem to me countries that are disdainful of the rights that he says he is upholding. And I hate to see those countries in particular furnishing a platform and protection for him in disclosing this information. But if I put that aside and I say, was it important to disclose this information? From my standpoint, the fact that the top-level official responsible for these activities lied to Congress about it and got away with lying to Congress about it makes Edward Snowden's activity a public service. And so the answer to my question to myself, or at least my own answer to the question, is yes, I do think he was justified in disclosing this information. Thank you very much.
Thank you very, very much for this clearly enlightening speech. And first of all, perhaps you allow me to extend a very warm welcome back to your native city, Berlin. We're happy to have you here. Of course, we'll take up questions very, very soon. But before we do this, let me perhaps introduce 3 keywords for the discussion that I would like to throw at you. One is technology and dimension. The second would be trade. And the third would be control mechanisms. Let me explain. I kept wondering, when you gave us your tour de force of the history of surveillance in the US, which is somewhat frightening to somebody who thought of the US always as the beacon of freedom, whether what we see now is really different in dimension because of technology. Never before in history, I suppose, it was so easy for surveillance institutions to catch as much information as they do, and to do it with so little effort. And one of the problems, and we get to this when we talk about control mechanisms, one of the problems obviously has been that many of those who would be in control of intelligence organizations weren't really firm enough, weren't really informed enough when it came to the technological options the NSA had. I mean, they were the real techie wizards, while the controllers were not. Secondly, seen from the other side, never before have citizens been giving up privacy so deliberately as they do now. We do post quite a few things, and we basically, of course, it's a difference whether we do it on our own free will or whether this is being surveyed without us knowing us. But we put a lot of things basically in the public sphere without being aware of it. So how much do you think is intelligence gathering and surveillance different in character when it comes to the technological options and dimensions?
I think it's very different in character. In a major respect, I actually think that the surveillance today is less bad than the historical surveillance, the pre-technological revolution surveillance, because in that era, people were targeted on the basis of dissent. And because we know that they were not only the targets of surveillance, but the information that was obtained through surveillance was used extensively to harm those people. And an enormous amount of harm was done by the pre-technological surveillance. In another respect, of course, it is worse today. It's worse because the technology makes it so much easier to gather the information, and such a vast amount of information on so many aspects of our lives can be collected very, very simply. And it does create the potential that this information is going to be used by somebody whose identity we don't yet know for some political purposes or for some punitive action against certain people who are the targets of surveillance. And of course it is dismaying that people feel that for a variety of purposes they should give away so many details of their lives so readily to institutions which exchange information technologically, and therefore they leave themselves at the mercy of what will be done with the information. In the earlier period in American history, we had all this surveillance, and then it reached a kind of crisis point in the era of President Richard Nixon. And Nixon came to epitomize for many Americans this great violation of privacy. And then we had a sharp reaction as manifested by the congressional groups and the court decisions and all of those things that took place in that era to end the surveillance. I don't know whether Edward Snowden will help to trigger that kind of reaction. So far, that has not happened in the United States. I would say that so far, I think the outrage that has been generated by Snowden's revelations is greater elsewhere than in the United States, and maybe greatest here
Probably, yeah.
and particularly the listening in on the Chancellor's phone calls is the kind of thing that seems to epitomize the wrongdoing in the surveillance. I don't know what additional revelations will take place. I don't know, for example, if there is any information that some of the surveillance data was being used or is being used for the kinds of harassment purposes that existed in an earlier era. If that were to emerge, and I don't know about it, I think it would trigger a very big reaction.
That would be a game changer.
That would be a game changer, but I don't think anything Snowden has revealed thus far is a game changer in the United States.
Interestingly enough, when it comes to the behavior of each and every one of us after Edward Snowden's disclosures of NSA activities, I haven't seen much of a change of behavior patterns when it comes to social media, for example. I mean, people have not been giving up their Facebook accounts or their Twitter accounts or whatever they do. But it leads me to the second buzzword, and that's trade. You've been mentioning this also this word or this issue in one of your articles in the New York Review of Books. There has to be a trade about what do we really want to give up in privacy for a certain amount of security.
Yes.
But the million-dollar question seems to me, how do we trade on this issue? How open can we be? What do we want from the official institutions, the surveillance agency? Do they have to be entirely transparent? Do we rely on a public debate, which is up to a certain extent taking place here, but not as much in the United States? And some people seem to be much less worried about this. So how do we get a proper trade balance here?
Well, I think we need, in broad terms, information about what's taking place.
What would be broad terms then?
Well, they used to say, for instance, in wartime with respect to freedom of the press, that you couldn't publish the date that a troop ship was going to sail, that it wasn't crucial in knowing about the conduct of war to know what day it would sail and exactly what route it would take. So there may be details of that sort, the counterpart of that you don't actually need to have a broad understanding of what is taking place. But you do need to know enough about what is taking place so that you can evaluate this from a policy standpoint and evaluate it in terms of whether the right to privacy is being violated. So the fact that the NSA was collecting this metadata on calls by Americans, that doesn't strike me as the kind of detailed information that they ought to be able to keep secret. That's broad information on what's taking place. That is, we are recording the information on which numbers call what other numbers at what time of day and for how long. I don't see how that damages the program. But I do think that one needs to know that, to be able to think for oneself, well, how much does that really intrude on my privacy? That kind of broad information, I think, ought to be available.
Asking the other way around, wouldn't that be an early warning for those we want to target? I mean, so far, the bad guys or terrorists, people who'd engage in some kind of attacks, if they're clever and smart, and they are, they won't use electronic means anymore. They won't use mail if they're basically
And if they won't use electronic means, and they won't use those things, they are going to be significantly hampered in their ability to launch terrorist plots. And I would like to significantly hamper them in that fashion.
I guess we all do.
My argument essentially is, if they assume that there is no monitoring of these calls, then they will probably make calls, and maybe some of them will be caught, and maybe some of them won't be caught. Because even when you monitor the calls, you aren't necessarily going to figure everything out.
So if
the NSA says, I mean, it's a strange case. They say that there was a phone call from the United States, from California, to a terrorist safe house in Yemen shortly before 9/11. And they picked up the call to the terrorist safe house in Yemen, but they didn't know that it was made from within the United States. And if they had known that call was made from within the United States, that would have been helpful to them in terms of detecting the 9/11 plot. I don't know why they didn't know that that call was made from California to Yemen. But suppose the person was in California and the person said, I can't call Yemen because if I call Yemen, they will be monitoring that call. They will pick up the fact that I'm calling somebody who is involved in plotting terrorist acts. So I'm stuck here in California. I really don't have a way of communicating with those people in Yemen. Maybe we would have been better off if the person couldn't make that call to Yemen.
Quite obviously, the trade part is one that has to take place or negotiated within society itself also.
If you are making a decision on giving up some of your privacy, you have to know to what degree your privacy is invaded.
Absolutely.
And you have to have a sense of what you're getting for it on the other side. Yes. What's the return? Are you really getting increased safety? And I think they owe us a duty to demonstrate that we're actually being better protected. And the information we have so far doesn't show that.
And obviously the burden of proof is on their side.
I think the burden of proof has to be on them.
Absolutely. Well, what we need then, too, is control mechanisms which would make sure, because when you come to the conclusion that obviously there was no other way but an Edward Snowden revealing what he has revealed, then obviously the control mechanisms and the control institutions that should have been in place have not been in place. And that obviously doesn't only have to do with somebody lying to Congress, but also with the Senate Intelligence Committee not knowing what was going on, with the president perhaps not knowing what was going on.
They may have known what was going on.
But what kind of control mechanisms would you like to see in order to make sure that, yes, the burden of proof is not only delivered, but there is a check-up on that every once in a while, that we can still be sure that the trade we've made in privacy for some security, that this trade is being kept, that it's being honored, and that it's being checked every once in a while?
I think the best way to protect privacy is public disclosure. Obviously, the way that was thought to be effective was that there would be these representatives of the public in the Congress of the United States, that they would know what was going on, and that they would act as the voices of the public in trying to protect the public. But there seem to be all kinds of institutional pressures which make it difficult or impossible for them to exercise that role. A couple of the people who have been involved in this process are people, I think, who very much take the issue of privacy seriously. And yet they have been constrained in terms of their own ability to speak out and their own ability to safeguard the public. So up to now, it seems to me the protections which we thought we had don't seem to have been effective. We do have a court which authorizes certain activities of the National Security Agency. The court has been stacked only the Chief Justice is involved in picking the judges who sit on that court. All of the judges he has picked come from his political party and represent his point of view on these issues. The hearings that are held by this court don't have any person appear before the court other than the representatives of the National Security Agency. One of the reforms that President Obama has proposed is that in certain of the court hearings, he has said, from now on there should be a privacy advocate who appears in that court. And I think that would be a significant advance. I think having somebody with that responsibility would be a very good thing. But I think the best way to protect privacy is for the people who are affected to have an idea of how their privacy is being invaded, and then themselves to be able to manifest whether they think the invasion is justified or whether they think the invasion is not justified, that their privacy is being excessively invaded.
I'm sure there are plenty of questions with you. There's one first here, and I'll give them microphones. Could you bring one here first? So in the middle, the gentleman with the gray hair here in the middle, third row. Thanks. And then it goes over to, yeah. If you stand up, it makes things easier to find you and to give you the microphone. Yeah. If you ask a very short question, would it make it easier to take all the other questions as well?
It's a two-part question, Mr. Neier.
The
first one is, in a recent interview with the New Yorker, President Obama said that the benefit of the debate on Snowden is that he generated was not worth the damage done, because there was another way of doing it. I think you partially answered that question before. The second part is, do you see this case ending up similarly to that of the Ellsworth?
I'm sorry?
Do you see the Snowden case ending up, perhaps in a few years' time, similarly to the way the Ellsworth case ended up?
Yes. On the first part, I read that interview with President Obama, and my follow-up question is, if there was another way, what way was there to disclose this information? And he wasn't asked that question, or he at least didn't answer that question. So I don't know what other way there might have been. As far as Ellsberg, or whether it will follow the pattern of the Ellsberg case, I don't know Snowden's intentions. Snowden is represented by legal counsel. I'm sure that his legal counsel will be discussing with the Justice Department whether there could be some deal for Snowden to return to the United States, and whether there might be a plea bargain or something like that. My guess is, but this is only a guess, my guess is that if they persist in wanting to prosecute him under the Espionage Act, that there will be no deal, and he will not return to the United States and expose himself to prosecution. I'll tell you a story. I always knew that Ellsberg expected to go to prison. And this was a serious concern. Ellsberg married a woman who was from quite a wealthy family. Her father was a leading toy manufacturer in the United States. He manufactured electric trains in the United States. And at the time, I was the director of the American Civil Liberties Union. And I was told that a woman named Patricia Ellsberg wanted to see me, and that she wanted to discuss a contribution. Okay, I'm happy to see her. She came to see me, and she told me that she was close to somebody who was going to prison. And she said she knew that we were doing things on behalf of prisoners' rights, that we had created a project on prisoners' rights. And therefore, she would like to make a contribution to our project on prisoners' rights. And she did make a substantial contribution to the project. I didn't ask her who she was close to, who was going to prison. I thought it was a period when a very large number of young men who were resistors to the draft for the Vietnam War were going to prison. And I thought she was probably related to one of the young draft resistors. Of course, when it was revealed that Ellsberg was the person who gave the Pentagon Papers to the New York Times, I put two and two together at a late point, and I realized who she was close to, who was going to prison. But that, to me, was indicative of his belief that he was going to go to prison for a substantial period for giving the papers to the New York Times.
We have two questions in row number 4, and then we go here. And perhaps we should collect these 2 or 3 questions, and I have 2 more questions over here. So, 4th row, if you stand up, please, because then it makes it easier to identify you. And then pass it on to the gentleman next to you.
Mr. Neier, an honor to hear you today. You said at the end he was justified in releasing this information.
Yes.
I wonder which information you mean, because only a small amount of the information released was related to the metadata programming violating American citizens' rights. People talk about 1.7 million documents, most of them having to do with foreign intelligence operations. And I just wonder, you mentioned briefly some things you're not allowed to publish, but do you have anything to say about that amount of information about foreign intelligence? And then the second point is the Foreign Intelligence, or the Senate Intelligence Committee, I believe this summer, voted against defunding the metadata program. It was revealed. There was a vote taken. Do you think now that the process has answered the question about whether metadata is justified?
Yeah.
Next, the gentleman next to you gets the mic then.
Can I answer those
Please.
questions? I don't know Snowden. I've never met Snowden. I have the impression that he is exercising discretion about the information that he is releasing. I differentiate Snowden from the people who were involved in WikiLeaks. It seemed to me that the people who were involved in WikiLeaks were releasing everything indiscriminately, regardless of the harm that would be done. Without going into detail, I was concerned in the WikiLeaks disclosures that I knew that there was information about a human rights activist in a country. The information was apparently contained in a telegram from the U.S. Embassy in that country to the State Department, and that if the information in that particular telegram were published, it would end up doing a great deal of harm to that person. That in the particular country where that person was, that information would have been highly discreditable. It would not be discreditable here or in the United States, but it would have hurt the person very badly. In fact, it would have endangered his life in that country. And I was involved in a couple of phone calls to journalists asking them not to report that particular piece of information. And they did not report that information. The information is still there, but it hasn't been published, and I hope it never will be published. It seemed to me that Julian Assange and company were utterly oblivious to any concerns of that sort and just released information because they had access to the information. My impression of Snowden is he's not proceeding in that fashion. My impression is that he is being discreet in releasing the information, that he's trying to blow the whistle on wrongdoing, but he's not trying to cause harm for the sake of causing harm. So I have tended to become sympathetic to Snowden. Now, he may prove me wrong. He may do something that I think is reckless, but I don't think he's done anything up to now that is reckless, and I think he probably had opportunities to do things. At this stage, I have tended to become quite sympathetic to him. As far as not defunding the metadata program, I think the members of Congress knew about it in advance. So I don't think the fact that Snowden has released this information publicly changes their awareness of it. I think the change situation is that other people know about it, but I don't think they're feeling pressure to defund the program. I don't think the American public has been significantly aroused by the revelations of Snowden. Maybe it's because the metadata program doesn't sound all that bad. Maybe it's because privacy isn't that highly regarded a right in the United States, or some combination of the two. Maybe it's because Americans take the threat of terrorism very seriously and want to err on the side of giving the National Security Agency the ability to engage in this activity in the thought that it might prevent terrorism. Could be all of those factors together. I don't know.
Just a quick note to the organizers. I know it's past 2 already, but I think nobody would mind if we'd go on another 10 minutes to take a few more questions. Sure, wouldn't we? Okay, so we have one gentleman more. I have you on the list, but then after this gentleman, we go over to this side. Yeah.
Hi, my name is Johannes Timm. I'm with the German Institute of International and Security Affairs, Stiftung Wissenschaft und Politik. I don't like to frame this issue as an issue of Germany or some other country against the United States. I think, as your presentation has made very clear, it's really a difficult issue within each society, and the US society is in the process of negotiating how they want to handle this, and so is society in Germany. I think something that's overlooked is that here we also have proponents of policies to invade privacy in the name of security. But still, given the fact that you also mentioned that there are very few legal limits to the NSA activities abroad, less limits than when it comes to American citizens.
Yeah, yes.
And given the reactions that we've seen so far from the United States, which haven't been very encouraging from the president, what would your recommendation be for the German government that it should do about the situation?
Yeah, my recommendation is that if Europe generally takes a united stand on these issues and says to the United States, we would like to have certain limits on this activity. We're prepared to negotiate with you about these limits. But we think that the intrusion on the privacy of our citizens is not acceptable, that the United States would have to take that seriously, and there would have to be negotiations about it, and that one might come up with a good policy outcome on these issues. I think in any such negotiations, the United States would have the burden of demonstrating to Europe that this is valuable in terms of limiting terrorism, and that if the United States cannot satisfy Europe on those grounds, then the demand for privacy becomes relatively stronger on the European side. If the United States is able to come up with solid information showing that Europeans are being protected by this surveillance activity, then I think Europe would be prepared to make certain concessions. So it seems to me an appropriate subject for a negotiation between Europe and the United States. I think it'll be difficult to do this on a one-country basis. I think it would work much better if Europe were to take a united stand on these questions.
Okay, while we are at the thank you department, I would very much like to thank you all. But before we finish, I would like to ask Wolfgang Reinecke, who's been a co-organizer of the event, to say a few words. Thanks.
Thank you, Sylke, for moderating this event this afternoon. I'd, of course, also like to thank our partner organization, the American Academy and ESMT, for co-organizing this event. And I'd like to thank all of you for coming here this afternoon. It seems like finally spring has arrived, and you nevertheless came here to listen to Aryeh Neier on such an important topic. But lastly, and most importantly, let me thank you, Aryeh, for being with us here today. We're very proud to also have you on our faculty. Last year, Aryeh Neier published a book entitled The International Human Rights Movement, A History. And some of you may have seen this. Michael Ignatieff wrote a review of this book entitled The Man Who Shaped History. And in closing, I want to quote from the concluding paragraph because I couldn't say it any better way. And I quote from Michael's piece in the New York Review of Books: "The movement, that is the human rights movement, founded 50 years ago, has miles to go. But it should pause and thank the people who got it this far. It can thank Aryeh Neier especially for an exemplary career. He and the thousands of people he drew into the movement have demonstrated what discipline, toughness, professionalism, and integrity can accomplish when up against the despots of our time." And this, of course, today and over the last 6 months has been more timely than ever. And on behalf of all of us, Aryeh, I want to thank you for coming here. I hope we can repeat this at some future time and continue the conversation. Thank you very much.
Thank you very much. Thank you.